Okay, well, good evening, everybody. Thank you for being here. I am Samantha Kolke, and I am the Director of Programs and Services at Center for Independent Futures. And tonight's webinar is focused on guardianship and powers of attorney in Illinois. So before I introduce our presenter, I want to take this opportunity to briefly share a bit about CIF. We are a nonprofit organization based in Evanston, and we're committed to meeting the needs of disabled individuals to achieve independence to lead fulfilling lives. We support individuals' hopes and dreams using our person-centered approach to enhance independence through one-on-one coaching, experiential learning, and shared activities. Outside of direct services with participants, we also offer consulting services. Our My Full Life digital learning platform offers a comprehensive, ready-to-use resource for life skills education and curriculum. The platform is user-friendly. We just relaunched it, and it's visually engaging, enabling instructors and learners to easily access tools, set goals, and track progress. Our platform is currently used in high schools and their transition programs, as well as other organizations. We also offer a 4-series workshop called New Futures Initiative. This offers family groups and organizations a step-by-step process to create their own supported and creative housing options. As many of us know, there are very limited options for housing for IDD folks. So this New Futures Initiative workshop is a unique offering that is very important in this landscape. I will include links to more of this information about the programs in the chat. And now for the main event, I would like to introduce Barry Lowy. Barry is the Director of the Office of the State Guardian with the Illinois Guardianship and Advocacy Commission. Part of his responsibilities are to promote and assist with legislation that positively impacts the lives of persons with disabilities. He has participated in efforts to pass legislation requiring training for newly appointed guardians and has developed nationally regarded online training for these guardians. Additionally, he has participated in helping to pass legislation expanding involvement of those under guardianship to participate in decisions about themselves, supported decision-making, and sex education for individuals with intellectual and developmental disabilities. Barry served in a variety of litigation roles with Equip for Equality on individual cases as well as class action cases. To say he is experienced in disability law and practice is an understatement. We are incredibly grateful that Barry is able to spend the evening with us here to talk about guardianship and powers of attorney. There may be time at the end for questions, so if you have a question, please type it into the chat box and we will respond to as many as we can after the presentation. If there's not enough time, then I will send out responses via email after the presenter has the opportunity to write a response. So Barry, take it away.
All right, if you can put the slideshow up, I'd appreciate it. Thank you. Good evening, everybody. I'm pleased to be here, and let's get started with our training. All right, slideshow, please. There we go. Okay, so let's talk about what is guardianship. Oops. Hello. Okay,
Is the slide up?
Yep, the slide's up now. Okay, guardianship is a legal relationship. It's established by a lawsuit. It is not a further extension of parenthood or familial relationships, friendships, or any of those sorts of things. It is a legal relationship. Friends and family can become guardians, don't get me wrong on that. But oftentimes in the litigation that I handled in my prior employment, 17 years at Equip for Equality, representing persons with disabilities, particularly a number of guardianship cases, I would say over 100. I would find that there were guardians where it was my way or the highway, as opposed to putting the person in the center of the decision-making process. And it would generally be a parent who is like, well, I'm mom, I'm dad, I know best. I'm like, well, you're not exercising your guardianship authority in a manner that's consistent with the law. You might be exercising it in a manner that was consistent when your child was a minor. So it's created as a result of a court action. You have to go to court. Up in Cook County, there is a form called a CCP 211. Downstate, it's called a physician's report or physician statement. You need to have one of these if you're going to go and seek a petition for guardianship and establish a guardianship based upon the person's disability. And adult guardianship is established only for persons with disabilities, except there is a little clause that talks about people because of drug abuse, excessive alcoholism, debauchery. That's one of my favorite terms in the statute. So it's kind of an old biblical term that we can place people under guardianship if they're debaucherers, etc. But the point of the matter is you file a lawsuit, you have to give due process, you have to have a doctor's statement, you have to go into court, you have to get a court order establishing it. Next slide, please. By the way, those doctor reports are only good for 3 months. So if it takes months and months and months to get to the hearing, they need to be reestablished. The examination has to be within 3 months of the date of the filing of petition. So if you get it within that 3 months and you get it before the court, it's good if the case takes longer to get to a hearing. But if you've waited, let's say 6 months after you file a petition, you're going to have to, wait, let's say you get the physician's report, then you wait 6 months to file the petition, it's stale. It has to be within 30 days of the filing of the petition. Guardianship really should be seen as a tool of last resort. The Probate Act specifically says that it should be ordered only to the extent necessary. I've handled cases where I've successfully defended keeping a guardianship from being established. I had a young lady who lived with her mom. Her mom provided like a lot of natural supports, helped get her into a supported curriculum at the community college. The girl took care of the pets, took care of her own ADLs, helped clean the house, helped cook. Mom and dad were going through a divorce, and dad wanted the Social Security disability money. And so he sought to become guardian and the representative payee. And we were able to establish that with mom's support, she didn't need a guardian. So natural supports can then provide a basis for the court to say, guess what? I'm required to order the guardianship only to the extent necessary, and it's not necessary here. One of the other things that and I think if you've participated in prior training on supported decision making, one of the things that a supported decision-making agreement is designed to do is to elevate and enhance and support those natural supports to kind of allow the person who is providing that support to have a little bit more legal access to records, have a little bit more legal right to be in the room with the person with disability to help guide them, to help counsel them to make their own decisions. They're not making decisions for them. They're helping them make their own decisions. There are other tools that we'll explore as well, which, like supported decision making, are an alternative to guardianship. There are powers of attorneys, also known as advance directive. The big difference between an advance directive and a supported decision making agreement is a supported decision making agreement. The person with the disability retains their right to make their own decisions and the capacity to make their own decisions. With an advance directive, what's happening is the person with capacity is saying, hey, at some day when I lose capacity, I trust this person to make decisions for me. It's a substitute decision maker. Incidentally, a guardian is also a substitute decision maker. In the eyes of the law, the power of attorney is superior to a guardianship. And in fact, the law says that the guardian, when appointed, if there's another power of attorney out there, that guardian takes their authority, they call it the office, subject to that power of attorney. So if you have, let's say, I've executed a power of attorney for property that I trust my brother to manage my large trust that I have. Because well, let's not use a trust because that's a separate document. But let's say I've got a large investment account that's not in a trust, and I trust my brother because he's an investment broker to handle that money, and he's pretty good with this. But then I lose my ability to make my own medical decisions, let's say, and I lose my ability to kind of manage my daily finances. So my sister goes and gets guardianship over me, but she doesn't get to control that large pot of money because I've established prior to the creation of the guardianship that power of attorney and the sister has to take their authority subject to the brother's control over the funds that were set forth in the power of attorney for property. And so those are some of the alternatives and how they interplay with each other. So we can get into that a little bit later. Next slide, please. We talked about supported decision making. We talked about durable power of attorney for property. There's something known as the power of attorney for healthcare. The preamble to the Healthcare Surrogate Act references those powers of attorney for healthcare. And it says that, boy, those powers of attorney for healthcare are to be recognized as the prime directive, so to speak, as to establishing a substitute decision maker to make healthcare decisions for an individual when they can't make their own healthcare choices. Because once again, the person, when they were able to, said, this is the person I trust to make my medical decisions, including end of life decisions, to perhaps withhold life sustaining treatment. Ancillary to the power of attorney for healthcare is an older document called living wills. I'm not going to really get into those. You see these for people who've had long established estate plans. You'll see those pop up. There's this unique document and statute called the Mental Health Treatment Preferences Declaration. That is a mouthful, but what that is, it is a mental health advance directive. They're created by a person with a serious mental illness in a moment where their mental illness is stable. And they say, sometimes things aren't so good for me, and I trust my mom to make decisions for me in the event that it happens. And the mental health declaration has different elections. You can elect that your mom can put you, and I'm just using mom as an example. Anybody can be nominated by the person with the mental illness. But let's say it's mom. I trust my mom with decisions to put me into a mental health facility for my treatment. And I also trust my mom to authorize these 3 drugs, but no others, because I don't like how these other ones make me feel. So there's a hospitalization election. There's a medication election. There is even a separate election for electroconvulsive therapy, ECT. In the old days, they used to call it shock treatment, but I mean, it's not the same as it was in the old days. I've had clients with serious depression that say this is the only thing that helps me. So let's say a person has serious depression, they don't want to be put into a hospital for treatment. They don't want to be given a bunch of drugs, but they're willing to take outpatient ECT. They can elect that in the mental health treatment form. And as I mentioned, that a guardian takes their authority subject to the powers of attorney that we've talked about as an alternative guardianship. And the reason why it's the free will act of the person when they were lucid, the establishment of a guardianship, the person is no longer, at least presumably or arguably, allegedly, able to make their own decisions. And so it's imposed upon them. It's not an elected choice that they make. That's the reason why in the eyes of the law, POAs are elevated over guardianship. I have dealt with service providers that will say, oh, we can't accept a POA. We can only accept guardianship. That is an absolute misunderstanding of the law in this area. Next slide, please. Inability to manage affairs is the basis for guardianship. Disability is not. My mom died when I was in law school. She had multiple sclerosis and was totally paralyzed. But that woman was so sharp, and she could work a phone with help like nobody's business. And nobody in the world ever thought my mom needed a guardian, even though she was totally ADL dependent on the nursing home staff for her care. In the estate of Fallows, which establishes a legal recognition of this, Mr. Fallows was a DOORS recipient, Department of Rehab Services. He had a personal care attendant, and he had assistance to homemaker services, those sorts of things. So in other words, he had wraparound supports in his own home that the state was helping to fund. And he knew how to access these benefits. He knew how to get his Social Security. He knew how to schedule his doctor's appointments, etc. Mr. Fallows finally got tired of being under guardianship, went to court and said, Judge, look, I know I'm a C4, C5 break, and I need this wheelchair to move around, but I can get anywhere I need to get with public transportation, the paratransit and whatnot. and I can do just about everything I need to do with the help of my support staff. I know that I need help with my ADLs and with eating and cooking and cleaning and whatnot, but I can self-direct all of that on my own. The court said, you know what? You don't need a guardian. And because notwithstanding his significant disability, the court recognized, and it's the law, that disability alone is not the basis for guardianship. It's your inability to manage your affairs for whatever reason, including debauchery, right? Next slide, please. Who may act as a guardian? You have to be 18 years old. Um, you yourself have to be of sound mind. Whoever makes that call is, it's out there. It's not really a defined saying that, okay, the doctor has to make the determination of sound mind, although if it becomes a contested proceeding, that might be the case. But the main thing that they're getting at is, okay, if you want to be guardian of somebody, you yourself cannot be under guardianship because you've been adjudicated disabled. If it's a plenary guardianship, more on that later. Illinois has kind of a three-tier structure of guardianship. The most common form of guardianship is that where a loved one, whether it be, a spouse, an adult child, a brother, a friend, any sort of thing like that, is a private guardianship is established. The person goes to court, says, "Hey, I want to help my brother out." The court says, "Okay, you're appointed guardian." There are certain requirements that that guardian has to follow. They have to, make sure that they're managing their money, in good faith and for the benefit of the person with a disability. Those are the biggies. Then, they act in their best interest, guided by their wishes, to make decisions for them. That's the world of private guardianship. The world of private guardianship is the most extensive world of guardianship. Then there's the world of guardianship for people who have lots of money and nobody in their life. And for those people, generally the public guardians outside of Cook County, they're appointed by the governor. But in Cook County, they're a wing of county government. It's the Office of Public Guardian. They cannot handle cases below $25,000. So for indigent people, they're excluded from helping. So who gets to help the indigent and who gets to help individuals in counties that have a lot of money where there is no appointed public guardian by the governor? That's the Office of State Guardian. That's the organization of which I am the program director and that I run. The Office of State Guardian is one of three divisions within the Guardianship and Advocacy Commission. We have the Legal Advocacy Service that represents individuals in mental health court with involuntary commitment and medication proceedings. We also have the Human Rights Authority that goes into facilities and investigates rights violations. They don't do public health job. They're not going in to see whether the care is substandard or not. They're going in to take a look and see if there were civil rights and individual rights violations in these facilities. But then the Office of State Guardian, we have about 5,000 indigent wards scattered across the state. And we go in quarterly and we visit them, we provide consents for them, and we help oversee the management of their money. In other words, we act as a guardian, but we are an institutional guardian. We are not family. We don't take them home with us. We generally rely upon the service provider network to help navigate accessing their benefits and finding residential placement for them and those things. So that's a three-tier system in the state, the most common of which is the public, not is the private guardianship system. The public guardians of Cook County, the downstate appointed public guardians, and the Office of State Guardian are the institutional guardians that are there kind of as a backstop when there's no family to serve. Next slide, please. Out-of-state residents, interestingly, can become guardians. So if, say, you have an adult child who's in a SILA, and you want to remain guardian and retire to Florida and establish residency down there, you can do it. Now, some courts may go, "Oh my, you're having a hard time exercising your authority from Florida. You haven't seen your adult child in 7 years. Maybe you should get up here and then file a report about the status of the ward's condition with me." So the courts have that authority to do that, but there's no prohibition on out-of-state guardianships. Next slide, please. You cannot act as guardian if you have been convicted of a felony and the court makes a finding that that felony is in any way, shape, or form related to the performance of your duties as a guardian. So I had one client where I really tried to get, it was 11 years. Her mother was just terrible to her under guardianship. And her brother, about 8 years prior to the hearing, had a DUI. And you're thinking to yourself, okay, but he's got a DUI, he can't drive her around to doctor's appointments. True enough. But the man went through rehab and had been sober for 7 years, and I was able to establish to the court satisfaction that that old DUI felony would not be relevant to the performance of his duties currently. And the court agreed and removed the mother and appointed the brother as guardian. Um, if you are a service provider and somebody working for you wants to take on guardianship of somebody living in, say, a residential facility, they are prohibited. Service providers cannot act as guardians. Next slide, please. We talked about this. Next slide. Incidentally, I do want to talk, and we don't have to go back. I just do want to say one thing. Any reputable person can petition for guardianship. In the world of private guardianship, it's very common to see that mom or dad goes in, both maybe, go in and petition to become guardians of their adult child. And what happens is, let me kill these pop-ups here if I can. So generally what happens is the petitioner, i.e. the parent wanting to become guardian, that's asking the court for it, also is nominating themselves as the potential guardian. I want to do the guardianship for my child. And so the one and the same are at play in that petition. But our agency, we don't petition for guardianship. So how is it that we get 5,000 awards if we're not out there actively seeking them out? Well, we get a lot of petitions from hospitals that file that need to do an appropriate discharge plan and an appropriate placement and an appropriate treatment, habilitation, medication plan. And so the hospital is the petitioner, but then we get appointed because the hospital is considered a reputable person. So any reputable person can petition, and they don't necessarily have to say, I want to be the guardian. They can say, I want somebody else to be the guardian. So, so that is in play out there. We talked about the physician's report. You got to have one if you want to get guardianship. If the person that's being subjected to the guardianship has an intellectual or developmental disability, this has been around now maybe 3-4 years. I actually testified in support of this in front of the legislature. A psychologist report, a licensed clinical psychologist report, can be used in lieu of a physician's report to establish that guardianship. So say you're a SILA provider, you've identified a friend that wants to be guardian, but they don't really have a lot of money to do the petitioning and get reports. And you happen to have had your applicant for benefits screened by or evaluated by a clinical psychologist. You could ask that clinical psychologist during that screening process to address the issue of whether the person needs a guardian and to what extent that's necessary. And then that report could be used without having to get a physician's report to establish that guardianship because the person in the SILA would have the intellectual and developmental disability that we're talking about. So next slide, please. This is really important to know, and this is especially, I mean, I get service providers that get confused on this, and I get family members that get confused on this, and a lot of times it seems like only the lawyers know this stuff, but this is pretty straightforward knowledge that folks seeking to get into this role need to understand. So there's something called temporary guardianships. They expire after 60 days, and they can be extended for another 60 days to a maximum of 120. These can be for both over the property of the person, say they're being financially exploited by someone. A loved one can go in and petition for guardianship to maybe block out the other family member that's embezzling. They can get an emergency order to freeze the accounts. And all of this can be done very quickly through a temporary guardianship. Same thing for emergency healthcare crises. They got into a bad car accident. They need surgery. There's nobody there to consent for them. I'm going to go and petition the court to get guardianship. That's not necessary because there's the Healthcare Surrogate Act out there, which we will talk about, but that is an avenue, and it used to be a very common one. And so what I'm getting at is that you can get into court very quickly, and I really would prefer to see temporary guardianships renamed into emergency guardianships because that's generally why people seek those. You got guardian of the person. That well, let me start out. You got guardians of the estate. Guardians of the estate control the money, the assets, which are things like bank accounts, motorcycles, cars, boats, homes, tangible property items, debts. Let's say they got a lot of credit card debt. The guardian of the estate is responsible for managing that debt. So take all those things that relate to money, push them off to the side. Who handles the decisions relating to everything else in the person's life? That's the guardian of the person. Guardians of the person, guardians of the estate can be plenary. That means the whole ball of wax. You get the guardian has the authority to exercise the full range of authorizations as set forth in the Probate Act. A limited guardianship can only do the things that the court order says they can do. They can be very, very modest. I had one case where a guy was being financially exploited and had gotten himself into a mortgage that he had no understanding of what he was getting into. And it was fraudulent by the lender, it was fraudulent by the person seeking it on his behalf. I was able to defend it, got a settlement agreement out there. The bank said, "Hey, counselor, you've impressed us that this guy doesn't have capacity to contract. So how's he going to sign a settlement agreement?" We went in on a one sentence order that the guardian is authorized just to sign this document. I had another case where the guardianship order was about 6, 7 pages long, single space, double space between the numbers, but single space within the authority, and it just went on and on and on. But when all of the things specified were completed, the guardianship was dismissed because there was nothing more to do because it was limited. Plenaries are long term and they can be lifelong for the person. Not necessarily always, but they can be. Next slide, please. We talked about temporaries. Next slide, please. And limited guardianships. Back one. There we go. So these limited guardianships that we talked about, the Probate Act considers those to be the lesser restrictive environment in the world of guardianship. And there's a big reason why. The Probate Act says that if a limited guardian is appointed, the court does not have to make an evidentiary finding that the person is disabled and adjudicate a disabled person and thereby stripped of their ability to make decisions for themselves. Only in the area that's carved out and given to the guardian does the guardian have the authority to act. And so the ward, and I know that's a repugnant term, but that's still the legal term, retains all other rights. And so they're not adjudicated disabled, so they can continue to keep their driver's license. They can continue to keep their FOID card. They can continue to contract. They could go out. Let's say it's involving just keeping the stock account and under the limited guardianship, but the guy's got other resources and wants to go buy a car. He can go buy the car. They're good to go there. So, but unfortunately, the limited guardianship should be the most common guardianship. They, in fact, are an uncommon version of guardianship. I'm not saying they're non-existent and never used, but the vast majority of guardianships in the state of Illinois are plenaries, long terms and full authority, stripping the ward of their rights. Oh, next slide. This is really, really, really important stuff, especially if you're a guardian of the estate. This is the money we're talking about now. The guardian of the estate has to collect, preserve, and inventory the money. What that means is they have to go out and make sure it doesn't get wasted or lost or misspent. So they have to collect it. Then they have to make sure that they nurture it, so to speak. That's preserving it for the benefit of the ward. And then they have to inventory it. They got to know what they've got, and they have to tell the court what they've got, and that's called the inventory. They have to manage it frugally and invest it and apply it for the care and comfort of the ward, the ward's minor children, and any adult dependent children they may have. Parking it in a 0.05% interest bearing money market account as the bank is not considered frugal investment. judges would rather see some of that money put into maybe a 5% interest bearing CD that's, will liquidate in 6 months, 8 months, depending upon the term. Maybe some very low risk bonds and stocks kind of thing. Something that's going to get a safe and secure return on investment without exposing the estate to a lot of risk, but not just parking it in something that's just basically, with the rate of inflation, going to result in the deterioration of the value of the money because of over time. Then there is a duty to account. Basically, money comes into the estate, money goes out of the estate. All of that activity in, out has to be spelled out like a ledger sheet and given to the court. This is a big one, and I've seen guardians slap their names on joint bank accounts when they're guardians with the ward's money and then steal it, mismanage it, all kinds of misconduct. That's called commingling. When you put your name on the person under guardianship's with the person with guardianship's name on the money, that's commingling because it now becomes yours as well. Or you take the ward's money and you stick it in your own personal bank account. That is just a abject no-no, and we'll get guardians in serious trouble. In fact, if it's willful and fraudulent, it could result in criminal prosecution. And then there's self-dealing, and this I would see this a lot in some of the smaller cases. Mom died, friend takes over the guardianship, lifelong family friend, willing to go over to the guy's independent apartment. He's probably getting intermittent Scylla services or something like that. The friend takes him grocery shopping on Saturday. Invariably, she shows up with an empty tank of gas on Saturday. Make sure she fills that tank up on his money and drives about 10 miles across town to get groceries, 10 miles back across town, drops him off, doesn't see him for another 2 weeks when they get groceries. So she's got 2 weeks worth of gas on his dime to go 10 miles. That's self-dealing, and it's inappropriate. Next slide, please. Next slide, please. We can save some time here on this. Next slide. Guardians cannot sell significant property, real estate, cars that are of value. We're not talking about the 1979 Camry that somehow still is managing to run. We're talking about the vintage 1967 Corvette that's still running. And so, anything of significant value, the guardian needs to get a court order authorizing them to sell it or dispose of it. Same thing with, like I said, expensive property that's not real estate, that the law calls that chattel. That's what this is referring to. Next slide. Okay, this is super important. The different types of guardianship, limited, plenary, temporary, long-term, those are really important concepts to understand. But once you've been appointed as a guardian, you have to know how you're going to exercise your authority appropriate under the law. And I was able to actually modify the Illinois Probate Act, amend it such that persons with disabilities are brought to the center of the conversation now by the guardian. You always hear, oh, the guardian's got to act in the best interest of the ward. The guardian's got to act in the best interest of the ward, as if that is what you jump to as best interest. It is not. The Probate Act says that the guardian shall maximize the independence of the self-reliance and the independence of the ward. It's right in the Probate Act that you got to do your best to elevate that person in all facets of their life. Next slide, please. We'll talk about residential placement after the next slide. Next slide. Right. This is what I'm trying to get at here. So the duty to maximize independence and self-reliance is effected in the Probate Act through the standards for decision making. And the number one standard for decision making now, as opposed to a number of years back, not that many, but a number, the guardian is supposed to search out the ward's wishes. Go to the ward, talk to them. What is it you want in this circumstance? I need to make a decision about this. What do you want? Okay. The guardian then still remains the decision maker, but their decision must be guided by the wishes of the ward, and the guardian is to make decisions in conformity with the ward's wishes. That's a big way of saying do what the ward wants. The caveat to that is the guardian is not required to do what the ward wants if it's going to cause substantial harm. The definition of substantial harm is not spelled out, and that was largely intentional because what is substantial harm when you're dealing with um, having your limb amputated to save your life is different from drinking a beer at a ball game. Okay, so it's context sensitive, the substantial harm. So a guardian is making a decision. They have to take the ward's wishes into consideration. They have to know the circumstances of the decision and the factors involved, and then they have to make a call whether it's going to result in harm to the ward. If the latter one's not there, they fall back on these three and they make the decision the way the ward wants it done. We call that person-centered planning. That was not in the Probate Act. What was in the Probate Act, and by the way, what I just described as how guardians are supposed to make decisions is referred to in the Probate Act as substituted judgment. That's a confusing term. Even when I interviewed potential caseworkers for our agency, we would ask them questions about, tell us the difference between substituted judgment and best interest. Nobody got it right. Substituted judgment, the standard says that the guardian is taking the ward's wishes and substituting it for their own decision, their own judgment. They're doing what the ward wants, not what they want to do or what they think should be done. In the landscape prior to the amendment of the Probate Act, what we had for substitute judgment was a look back in time. So Barry's doing just fine right now. Barry goes out to get his newspaper, gets hit by a car. Thank God I don't have a newspaper anymore, so I don't have to worry about that. But let's say that were to happen, and now I need to have a decision made over whether I want to have whether I need life-sustaining treatment. Well, I have a wife, and I told her, really, that's not something I want to. I don't want to be kept alive on a ventilator for the rest of my life. So there's no real hope of recovery. Please don't keep me alive. So the hospital has to make a decision, and my wife says, well, we're going to go ahead and we're going to withhold life-sustaining treatment because he did not want that. It's a look back in time to when I was lucid. She's now substituting my lucid statements for her judgment in making the decision to let me go. She might not want to do that. It might be very hard for her to do that. It might be excruciatingly difficult. It might take her quite a bit of time to come to that conclusion. But if she's making decisions in the way the Probate Act expects guardians to make decisions using substituted judgment, she would let me go. So substituted judgment now is take into consideration the ward's currently expressed preferences. If those are not available, use what the ward told you before when they could tell you. And if neither A or B are present, now the guardian makes decisions based on the best interests of the ward. That's very on its head for the thinking of most people, but that's how the law says guardians are supposed to make decisions. And I will tell you, I've handled dozens and dozens and dozens of cases where I've asserted that legal standard, and I've been able to remove a guardian because the guardian's approach to their guardianship was it's my way or the highway, and I'm making decisions. And this daughter of mine, she's not wearing lipstick, she's not wearing fingernail polish because that's against my religion, and it used to be her religion, and that's the way it's going to be. Barge into Scylla, throw her the stuff out that she bought with her own money because I get to make decisions, and I deemed it to be in her best interest that she doesn't have this stuff. I mean, that kind of decision making really irked me, and it's part of why I pushed so hard to get the Probate Act amended so that persons with disabilities are brought into the conversation. I know there's kind of a saying that people say nothing about us without us. Well, this is the probate's way of saying that, Probate Act's way of saying that. So I know I've belabored this, but it's really important on how guardians are supposed to properly exercise their decision-making authority. Next slide, please. Okay, this is an interesting, these concepts get confused and merged, and they're very distinct concepts. You have decisional capacity, you have legal competency. They're not the same thing. Legal competency is a declaration by a judge that you don't have the capacity, the competency, the ability, and now when after the adjudication, the right to make your own decisions. That is a legal standard imposed by a judge that says that you legally don't have the right to make your own decisions. The right to make your decisions is now vested with the guardian. However, in the state of Illinois, we have something called the Healthcare Surrogate Act. And the Healthcare Surrogate Act was passed to address the situation of end-of-life decision making by guardians and the difficulties that those circumstances impose. And the legislature said this in the beginning of the Healthcare Surrogate Act. Every person retains the fundamental right. Those are strong words. That inures to people whether they're under guardianship or not under guardianship. They retain the fundamental right to make their own medical decisions. Only when a doctor declares, particularly at the end of life, the doctor has to make a declaration that the person's basically going to die, even if we do this medical intervention, and they're going to die from this very, very serious condition. It's called a qualifying condition and decisional capacity. And it takes a second healthcare professional to affirm what the doctor's saying, that they lack these things, that they have this condition and they lack this decisional capacity. Now, for decisions outside of the end of life realm, it still is a doctor that makes a determination that the person lacks the up here, not the legal standard, but lacks it up here to understand basically how to give informed consent, risks, benefits. They can't hold those two things in their minds. Okay, and I could go into a number of case examples which I think are very illustrative, but we're kind of getting a little tight on time, and I don't want to completely give people the I want to give people at least some chance to ask some questions. So understand this. Doctors decide whether you have the ability to make your medical decisions. Judges decide whether you have the ability to make the other decisions. Next slide. We talked about that. Next slide. We talked about the healthcare surrogate. Oh, one thing that's really important about the Healthcare Surrogate Act, and this is a big deal, is it says those folks are presumed to have the capacity to make their own healthcare decisions, and that intellectual and developmental disability or mental illness of themselves, that's the term, it says of itself, is not a reason to find that the person lacks decisional capacity to make their medical decisions. So generally, you have to have something else co-presenting along with the intellectual or developmental disability or the mental illness. We will get in our agency requests from hospitals, doctors, to give us consent to let them withhold life-sustaining treatment. And the basis for the lack of decisional capacity by the doctor says has mental retardation. That tells me, first of all, they're old school. They're using a term that's not in use anymore, considered to be by many vile. The other thing that it tells me is that this doctor doesn't know the Healthcare Surrogate Act, because intellectual and developmental disability alone is not the basis for determining a person lacks decisional capacity. Next slide. Sterilization. There used to be common practice that guardians would just waltz their wards off and sterilize them. And they can no longer do that. They have to go to court and get court permission, and there's quite a procedural layer that has to be followed. But basically, what the court is doing through all that procedural layer is determining if the ward retains decisional capacity, and what is it, if so, what is it that they want. If what they want is expressed appropriately and reasonably, the court tells the guardian, do what they want. If they want to be sterilized, consent to it. If they don't want to be sterilized, find some other form of birth control. We're not sterilizing them, not now. And so that's kind of the lay of the land now about sterilization. Next slide. The ward has a fundamental right to marry. The Supreme Court recently in McDonald handed down a case that really confuses this right. And basically, it's recognized that it remains a fundamental right, but it has to be exercised through the guardian. So the guardian, if the ward wants to marry, should be bringing this to the court's attention and getting direction from the court as to whether the court determines that this person should be allowed to proceed with the marriage and get married, or whether this would be something that would really could pose a risk of serious harm to the ward and therefore not allow it. We're trying to do some legislative things to address this, but that's the current state of the land. So a guardian, if they really want to be kind of my way or the highway, they can say, I'm not even going to court. And so the ward's fundamental right gets stymied right then and there. And so there needs to be some outside mechanism to challenge that guardian and to assert that individual under guardianship's right to marry, because it is fundamental, but it is conditional upon being exercised by the guardian. Next slide. And psychotropic medications and being forced into a mental health institution, guardians have no rights to do that. There's a case that I handled at a QIP called Mueller versus Blessing Hospital, which got rolled into the Probate Act, and it said that a guardian has no authority to admit a non-consenting ward to a mental health facility against their will for the treatment of their mental illness. I can't tell you how many guardians want to go to court so they can institutionalize their loved one with mental illness. They don't have the authority to do that. Likewise, if the ward is objecting, I don't want those psychotropic medications, they have no authority to consent to that. Now, there's the gray area where the person needs to be taken to a psych hospital, and they're generally pretty out of it, and they can't even really object to it. So do you want to go to the hospital? And they kind of nod, they shrug, they don't know. They're not objecting, so you can take them. Likewise, if a person is handed the pills in, say, the hospital, and they turn around, they walk away, that's objecting. They're voting with their feet. If they're willing to take the cup and swallow them without saying a word, they're consenting. So there's some gray areas in that legal precept, but it's pretty strong that guardians had no authority really to assert their will over the will of the ward when it comes to serious mental health treatment. Next slide. Guardianships can be challenged. They can be challenged by the ward. They can be challenged by outside parties, say APS, Adult Protective Services, those types of things. A modification of a guardianship addresses the exercise of the guardian's authority. It doesn't necessarily remove the guardian. That would be a petition to revoke the guardianship. You can revoke a guardianship and replace a bad acting guardian, or you can revoke the guardianship and restore the person to their rights. That's called a restoration of the ward. It is really important to understand that outside persons, service providers, family members, you name it, have the right under the Probate Act to bring to the court's attention problems that the guardian is presenting, whether they think they're embezzling their money, whether they're blocking visitation of a family member, whether they're not allowing them to get appropriate medical care and treatment. The person any interested party has the right to communicate with the court. Generally, it's done through a letter, if you know the judge's email, that kind of thing. But you can even appear in court and tell the judge you have problems. You can even call the judge. What the judge does with those can be as varied as if they want something, have them file a motion, which tells me the judge doesn't really understand this clause of the Probate Act or this provision of the Probate Act. Other judges will do the right thing and appoint a guardian ad litem. A guardian ad litem, also known as a GAL, is the eyes and ears of the court, and they're supposed to go out and investigate and then tell the court, yeah, I think this guardian is doing something wrong. In that case, the GAL is actually supposed to file a petition with the court to bring the guardian's wrongdoing to the court's attention. Restoration of rights. If you have a doctor's statement saying the person should be restored, if the guardian says it's in the best interests of the person to be restored, and the person wants to be restored, it's pretty much binding on the court that they will have to restore their rights and dismiss the guardianship. Next slide. Guardians that are being abusive to their wards, you can bring an order of protection against them, and you can bring that petition seeking that order of protection in the guardianship case. What the court is supposed to do, I find courts to be reluctant to do this, but they're supposed to say, okay, guardian, we're going to put you on the shelf for now. We're going to appoint another person and we're going to sort this mess out. And if it's found that you really don't need to be guardian anymore, we're going to remove you. So it puts that guardian's authority on hold while the matter gets investigated and litigated. Okay. That's called a temporary substitute guardian. Next slide. And then we talked about some of the alternatives to guardianship. Your power of attorney for healthcare, that's a counterpart to the guardian of the person. Durable power of attorney for property, that's the counterpart to guardianship of the estate. Your mental health preference declaration is out there. That is a mechanism that gets past that preclusion that the guardian can't exercise authority to render decisions relating to mental health treatment, because they now have the authority via this document, which was given to them by the person with the intellectual and development, by the person with the mental illness. And then we have supported decision-making agreements, which we've talked about quite a bit. That is where a person with the disability says, I want help. There's different areas they can say, I want help with. They express, I want maybe with school, maybe with making healthcare decisions, etc. Accessing public benefits. And then there is a statement in there that says, I want my supporter to be allowed to get these records, whether they be school records or health records, that kind of thing. This should be the last slide. Next slide, please. There's where you can find the document for supported decision making. That's the bill. This is kind of an older slide. You can see it's dated 2022. So let's move on. And that's that. Well, somebody seemed to like the presentation. Thank you.
Thank you so much, Barry. So
I know I kind of ran through that. There's this
I know
presentation. I can double this presentation and I can present on it for 3.5 hours, and I have.
So if people have a minute, or not a minute, 5 minutes to see, okay. Because I did not ask Barry about that.
We got a little bit of a late start. 5 is
okay.
fine. I have things I have to get to, but five or so is fine.
Sounds good. Okay. So somebody asked, our guardianship was established in New Jersey. We have not changed it, and our special needs law firm here in Illinois said we didn't have to change it. We do have power of attorney in healthcare and another one that is a general power of attorney. What is your opinion about changing it to Illinois?
That's asking me to give specific legal advice when the person's represented by counsel, so I'm going to decline to answer that question.
Got it. Noted. Okay, so my son is 19 and has Down syndrome. I have a power of attorney for healthcare. Can I, as the healthcare power of attorney, so they give an example. If he gets into a car accident and needs life-saving surgery, he is still conscious and can make decisions. He's scared of surgery and will not consent to it. Can I, as healthcare power of attorney, make the decision for him to have the surgery, and that overrides him saying no?
Two-part answer. I'm going to give you the short answer, and then I'm going to give you the long answer, because this is complicated, and I've actually litigated these things in court. This kind of end-of-life litigation stuff, and it occurs at a very quick pace. You, as power of attorney, if he is deemed initially lucid and can make his own decisions, you generally do not have that authority as power of attorney for healthcare, because that power of attorney only becomes effective when he loses the ability to make his own decisions. Now let's move to a little bit grayer area. The Healthcare Surrogate Act says, yes, we look to powers of attorney to make decisions. This power of attorney can't make decisions because let's say your son who has Downs is saying, no, I don't want that. It scares me. That terrifies me. There's no way I want to have my foot amputated. Even though you can amputate the foot, save his life, give him an artificial limb, he can go do his Special Olympics or whatever Olympics if he's got the wherewithal and the ability to do that. So, but he can't get past the fact of losing that foot. So the doctors are like, well, he really doesn't want to lose this foot. And now the doctor feels like they're uncertain and they're sitting on the fence, and they've got the family members going, yeah, our son can make some pretty good decisions for himself, but this might be a bridge too far for him. I have seen it where doctors will go to the hospital ethicist. Every hospital has an ethicist on staff. And they'll say, boy, I got a medical ethical conundrum here. What do I do? The ethicist goes, well, okay, this seems to me to be an issue of whether this young man has capacity to make the decisions, thereby knocking his powers of attorney out of the box. And is he making a reasoned decision? Hey, let's call in a neuropsychologist to do an evaluation. And I've actually seen where I've seen where the person goes in and out and in and out of lucidity to make their own decisions. It becomes a very complicated fact pattern. But let's say the hospital invokes that. Let's say the neuropsychologist comes in and determines that the person has a qualifying condition. If they don't take off this foot, they're going to die. And there's nothing we're going to be able to do once sepsis sets in and gangrene and it spreads. They're going to be done. But we can do something to help that person really live a full life if we can address it. Does the neuropsychologist think that he has decision capacity? No, he's not able to weigh the risks and benefits. He only sees the risks, he doesn't see the benefits. The neuropsychologist then comes in and says, I find that he lacks decisional capacity. The doctor breathes a sigh of relief, says, I agree. You got two healthcare physicians. The power of attorney is no longer being exercised. What happens is the hospital says, under the Healthcare Surrogate Act, we have a responsibility and a duty to find a surrogate decision maker for this young man because he's not able to make these decisions and he has a condition from which he'll die. Classically, this is done in a withdraw the life sustaining treatment, but here the life sustaining treatment is to be administered to save the person's life and the foot is removed. So the power of attorney no longer becomes effective, and you then slide into the land of the Healthcare Surrogate Act. That's complicated legal stuff. That really is. I hope that you see that there's two different statutes and two different things in play here. One is an advance directive, one is an imposed decision maker.
This makes sense why a hospital has an ethicist on staff. Um, this may be the same answer you have. So if let's consider the same situation that was given before, but the person is the guardian, does that change your response?
Nothing.
Okay.
Nothing. Because here's what the Healthcare Surrogate Act says. The Healthcare Surrogate Act says once the doctor decides that the person has a qualifying condition, and the doctor determines that they lack decisional capacity. The Healthcare Surrogate Act says then, okay, look over here to this side of the statute. We have a list of people that are preferred decision makers. The number one person on the ladder to make decisions is the guardian of the person, then the spouse, then an adult child, then a brother, uncle, blah, 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 blah. Close friend. Guess who's last on the rung of those authorized to make serious medical decisions that could lead to the death of the person? That would be the guardian of the estate. And I have seen where guardians of the estate have abused their authority and have sought to put the person to death so they can inherit a bunch of money from them, as opposed
Mhm.
to provide the treatment that they need. And it was an ugly case, and I could spend about 45 minutes explaining what I did to the Department of Public Health to address that problem. But the fact that you have guardianship just slides you into a preference under the Healthcare Surrogate Act. It does not give you the independently to make that decision. And I have litigated those cases because I have had guardians go, nope, I'm guardian. I get to make that decision. It's my way or the highway. That's not the case.
This is really helpful because it's very different than what
Everybody
we would
knows.
assume is
Yes.
like lay people for what.
The guardian gets to make the decisions. They are the preferred decision maker, assuming they're guardian of the person. And you can be guardian of the person and guardian of the state. And just because you're guardian of the state doesn't mean that it negates your guardianship of the person. It
Mhm.
just means that if you're only the guardian of the estate, there's suspicion around you being the decider.
Okay. This is the last one, which I think will be very quick. So can you please explain or clarify more about the plenary guardian?
Yeah, plenary guardian basically means, okay, I got an apple in front of me. Do I get to eat the whole thing or do I only get to eat part of the thing? If I get to eat part of the thing, that's called a limited guardianship. And the court's telling me which part I get to eat. And the other part I don't get to eat because the court didn't tell me I get to eat it. Plenary guardianship says, yeah, go ahead and eat the whole thing. That's a very simplistic way of explaining. Plenary guardianship means you get to basically make all the decisions for the ward.
Got it.
Using the standards for decision making, substituted judgment, best interest, but you get to make them all. Limited guardianship says only these over here you get to make. That I tell you, as judge, you can make.
Thank you. This is very helpful, very informative. I learned a lot, and I've done a lot of set in a lot of presentations on guardianship and powers of attorney, and this one has made the most sense to me. So thank you, Barry. Uh, so I want to thank everybody here for joining us this evening. The recording will be emailed to those who registered. In our last webinar, the next webinar in the CIF 2025 webinar series is next week, Thursday, May 8th at 6 p.m. With Heather from A Love of Special Learning. She will join us for 2 parts, but you can register for the one next Thursday and the one at the end of May, or you could just attend one. It doesn't need to be attended as a pair. So Heather will join us for part 1 of her 2-part series that's closing out CIF's 2025 spring webinar series. The link to read more about this and to register is in the chat. And I hope everybody enjoys the rest of their evening. And Barry, thank you so much for staying longer. Appreciate it.
You have a good night.
Have a good one.
Hey.
Mhm.